Welcome to the Implementing CDBG webinar series presented by the New Hampshire Community Development Finance Authority, also known as CDFA. My name is Ed Geiger, and the topic for this module is Grantee Requirements. You can download a copy of the PowerPoint slides for this webinar from the CDFA website for your reference. Let's get started. This CDBG training webinar covers a broad range of grantee requirements. These topics include several regulatory compliance items that do not easily fit into other topics because of their scope. However, this slide and the next provide a brief listing of those compliance areas we will cover in this webinar. Citizen participation cuts across the entire timeline of approved CDBG projects. While it starts with the application phase, there are other steps beyond that. Fair housing and equal opportunity have important elements that many grantees are not familiar with. The required steps impact all projects, even if the grantee is not performing housing activities. This slide captures the other topics we will cover under the Grantee Requirements webinar. Grantees must address any conflicts of interest that occur in administering a CDBG project. There are signage requirements for construction projects. Also, all grantees must have a drug-free workplace policy in place. Finally, we will cover the local grievance procedures that must be put in place. As a local official in your community, you know that your projects have a better chance of success when you involve your citizens from the beginning. The same is true with CDBG projects. Citizen participation is required by Section 104A(2) of the Housing and Community Development Act. Compliance with citizen participation requirements reduces the number of legal challenges and citizen complaints you may experience as a CDBG administrator. Grantees must provide and encourage citizen participation that includes low and moderate income residents, also called LMI persons. Those efforts should specifically target the areas where CDBG funded activities will take place. All grantees must also conduct at least 2 public hearings during the course of each project. The public involvement process must give timely notice when conducting local hearings and soliciting public comments. Such public notices must be published at least 10 days prior to the local hearing. The citizen participation process must accommodate disability and language needs. The citizen participation process must accommodate disability and language needs. The meeting location and notices must be accessible and inclusive of persons with physical disabilities who want to attend or comment on community development needs and any proposed applications. And accommodations for public input must include assistance to persons who do not speak English and may require language services. Note that grantees must be responsive to complaints and grievances as part of the citizen participation process. Last, but certainly not least, you must adopt a citizen participation plan that documents the procedures you will follow to assure citizen participation. The implementation plan includes a sample citizen participation plan, which is consistent with the state's citizen participation plan. Your local citizen participation document can be included as a component of your housing and community development plan that is to be updated every 3 years. We will cover more detail regarding the compliance steps for persons with limited English proficiency and handling grievances or complaints later in this webinar. All approved grantees must conduct at least 2 public hearings at different stages of the project. The first must be held before a CDBG application is submitted to CDFA. The second public hearing must be held prior to the closeout of the grant, but no earlier than the anticipated midpoint of the project. An additional hearing is required if substantial changes arise in the course of your project, such as changes to the scope, adding or removing an activity, the location, an increase or decrease in funding by 25% or more, or changes in the projected number or composition of beneficiaries. The first public hearing needs to review community development and housing needs, including your local housing and community development plan, the amount of CDBG funds available and expected to be applied for, range of activities proposed in your application, the amount for benefit of LMI persons, as well as a discussion of your anti-displacement plan. The second hearing to be held roughly at the midpoint of your project must cover project progress, construction activity, results and any beneficiaries as of that date, as well as the budget status for the project. If an additional hearing is required because of significant changes that occurred during your project, that hearing must cover the same items as the first hearing, but instead of housing and community development needs, which were discussed at the first hearing, you should discuss the need or reason for project changes. Now we will move on to review fair housing and equal opportunity requirements. The main point of this section is to impress upon you that as a recipient of CDBG funds, you have a fair housing responsibility, even if you aren't running a housing program. You must also assure that equal access to program benefits is provided to all your citizens. What if your daughter or grandchild were denied housing because she's a single mom? What if you were low income and denied federally funded work opportunities? It happens and it's illegal. These situations are why protections have been put in place. In this module, we'll talk about the fair housing and other non-discrimination requirements in your CDBG funded project. Because your community receives CDBG funds, you're responsible for ensuring equal and fair treatment of your citizens. First, by taking proactive steps to achieve this goal through fair housing activities, providing economic and job opportunities, as well as addressing the needs of people with limited or no ability to speak English. It's important for you to be aware of fair housing and non-discrimination requirements because you are responsible for assuring compliance with those laws and regulations. It doesn't matter what kind of project you're doing with CDBG funds. These requirements always apply for grantees. Fair housing requirements and activities must be completed even if your project is a water or sewer line, not a housing activity. Also, you have economic opportunity and employment-related requirements to fulfill even if you're not doing an economic development project. The Fair Housing Act establishes 7 classes of people that are considered to be protected from discrimination. The Age Discrimination Act added discrimination on the basis of age as another protected group for programs or activities receiving federal financial assistance. Additionally, this list of 8 protected classes has been expanded via state law and HUD regs and notices. New Hampshire state law adds age and sexual orientation to the list of protected classes. Marital status is another category of discrimination prohibited by New Hampshire court decisions. Further, HUD has issued regulations and notices that expanded the protected classes to include sexual orientation or gender identity, as well as persons who use service or support animals. Every grantee must promote fair housing practices within its jurisdiction for anyone within these protected classes. HUD requirements go beyond prohibiting discrimination. All local grantee recipients of CDBG must certify they will affirmatively further fair housing. As mentioned previously, this applies to all grantees regardless of whether you are doing housing projects or any other activity. This requirement is based on the Housing and Community Development Act. All grantees must affirmatively further fair housing. The obligation to affirmatively further fair housing has never been defined statutorily. However, HUD specifies in its Consolidated Plan Final Rule, 24 CFR Part 91, that a grantee, in this case that refers to the state, must first conduct an analysis to identify impediments to fair housing choice within the jurisdiction, and second, assure that both state and local grant recipients take appropriate actions to overcome the effects of any impediments identified through the analysis. Based on the experience that other states have encountered when monitored by HUD's Office of Fair Housing and Equal Opportunity and having to negotiate what is an appropriate level of fair housing activities, CDFA is requiring the following steps of all grantees. First, the analysis of impediments, or AI, is a responsibility that the state has to address, but grantees should review it or the AI from neighboring local jurisdictions for guidance. Second, develop and adopt a fair housing resolution as a policy statement that the local government will not allow discrimination and will affirmatively further fair housing. Third, implement a fair housing activity each time you receive a new CDBG grant. Fourth, display the fair housing logo on all housing-related notices, advertising, and brochures. CDFA also recommends the logo be displayed on all municipal stationery. In addition, grantees must place fair housing posters in conspicuous places for your local government and any other administrative offices participating in the CDBG program. Fifth, include non-discrimination provisions in all CDBG-funded and project-related contracts issued, including businesses, developers, contractors, subcontractors, and homeowners. Finally, if you have a project developing 5 or more units of housing, you must establish an affirmative marketing plan for those assisted housing units. In determining the activity you will complete as step 3 on the previous slide, here's a short list of ideas of fair housing activities that grantees could undertake. Good ideas to fulfill this requirement include providing outreach and positive reinforcement about fair housing through publicity, education, and community events. Many other ideas are included in the CDBG implementation guide. Other activities not on this list or not in the implementation guide may also be acceptable. Consult with CDFA staff if you want to propose an alternative activity not included on these lists. You will be required to document and report to CDFA on the fair housing activity that you complete. The Civil Rights Act of 1964 and Executive Order 11246 and other statutes establish prohibitions on discrimination in employment. The list of protected classes from the executive order includes race, sex, creed, religion, color, and national origin. Other statutes expanded this list to include age, disability, genetic information, and military history. Also, require that your contractors place equal employment opportunity posters on your job and project sites. Equal employment opportunity, EEO, provisions apply to any organization or business with a contract, subcontract, or combined contract totaling greater than $10,000 in a 12-month period. Grantees should include EEO and affirmative action provisions when soliciting and contracting for goods, construction, or professional services. These documents should prohibit discrimination by those firms and any subcontractor receiving CDBG funds. This and the next several slides highlight your requirements to address the needs of people with limited English proficiency, or LEP. The Civil Rights Act of 1964, Executive Order 13166, and citizen participation regs require that grantees take reasonable efforts to provide language assistance. The steps outlined in this slide are necessary to determine the level of assistance grantees should provide, including possible translation of vital documents and/or oral translation services. All grantees must perform the 4-factor analysis. Depending on the results of that analysis, a language access plan, or LAP, may be required. Then all grantees must provide an appropriate level of language assistance based on these assessment steps. The 4-factor analysis must be performed by all grantees for all projects. The first 3 steps examine critical thresholds to determine the level of language assistance that must be provided. First, examine the size of the LEP population. If less than 5% in population and less than 1,000 persons, no written translation is required. This is generally true for projects in the non-entitled areas of New Hampshire. However, you are still required to examine the other factors. Second, assess the frequency of LEP persons encountered. Will the project provide direct assistance to beneficiaries? If so, you may have significant contact with LEP persons, even though your LEP population does not meet the HUD threshold. Third, consider the nature or importance of the project to LEP groups. Will the project target an LEP population? For example, Assistance provided to a Hispanic community center would have significant impact on that LEP group. The last factor considers cost in determining what assistance will be provided. Cost cannot be a reason to not provide service. If the four-factor analysis indicates a significant need, prepare a language access plan, or LAP. The implementation guide includes a sample LAP that grantees can follow and customize easily to local needs for language assistance. The final step in addressing LEP needs is providing language assistance. Either provide the language assistance identified in your LAP plan, or if no significant impact on LEP persons is identified, you must still offer language assistance as requested. Remember, even if you do not meet the thresholds requiring translation of documents, you must still provide language assistance for citizen participation and non-discrimination reasons when requested. A good step would be to consider training local staff to use I Speak cards that can help identify the language spoken by someone seeking assistance or information about your project. Also, you can learn how to use free online language translators to provide language assistance when requested, or work with local organizations that may offer translation assistance. I Speak cards and some translated materials are available at the website listed on this slide. Conflicts of interest are another important grantee requirement to address. A legal definition of a conflict of interest is a real or seeming incompatibility between a person's private interests and his or her public or fiduciary duties. HUD has specific prohibitions when such a conflict arises. No person who performs any CDBG function or who has any CDBG responsibility, who is in a decision-making position, or who has inside information may obtain a financial interest or benefit from an activity funded in whole or in part with CDBG funds. Attempting to do so creates a conflict of interest. Any such conflict of interest should be publicly disclosed, including how the grantee will address the conflict. In general, a conflict of interest would exist if any municipal official or administrator in a decision-making capacity benefits from any portion of the CDBG program. Conflicts may occur when procuring supplies and equipment, construction contractors, or professional services, acquiring or determining disposition of property, providing a direct benefit such as housing rehabilitation, utility hookups, or facade renovations to local government officials, subrecipient officials, or persons administering the CDBG project. Conflicts of interest may potentially involve a subrecipient as well as a municipal official, particularly if the person is an official of the subrecipient agency or in a decision-making capacity. That status of decision-making is always a critical factor to consider, even more than job titles or level of work performed by the individual in question. Conflicts can also arise involving immediate family members and persons with business ties to a person in a decision-making capacity. We will briefly review the two types of conflicts: beneficiary and procurement. Beneficiary conflicts occur when someone is eligible for and seeks a direct benefit assistance from a CDBG project, such as housing assistance or assistance with a utility line connection to their home. Some individuals with a conflict of interest may have only a tangential relationship to the receipt of the CDBG project funds, but hold an official position that creates a conflict of interest if they were to receive benefits. The grantee should acknowledge any such potential beneficiary publicly, either announcing it at a local government public meeting or via other public notice to disclose the conflict. The grantee should seek a solicitor's opinion regarding the nature of this conflict of interest. Then the grantee should submit a request for waiver from CDFA. That request should address the criteria for exceptions outlined in the implementation manual. Procurement conflicts occur when procuring goods or services for the CDBG project, which includes subcontractors funded by the CDBG project as well. Waiver of this restriction is not likely. Any conflict of interest must be disclosed regardless of whether it will be waived or how the local government will address it. For example, a person with a conflict may announce withdrawal of a bid, quote, or proposal, or the grantee may announce that such a submission was not evaluated. It was rejected due to the conflict, or discuss a request for approval from CDFA based on specific circumstances. The person with a conflict must be completely removed from all aspects of the decision-making for the project, including solicitation, review and selection of award decisions, and administration of the project. Seek CDFA approval if there are mitigating circumstances or perceptions of a conflict that need to be addressed. Just like a beneficiary conflict, use the CDFA request for waiver form. That waiver request must include a detailed description of the circumstances, address the criteria for exceptions outlined in the implementation guide, and include a legal opinion from the local solicitor stating that the potential for conflict of interest is minimal and that the situation does not violate either state or local conflict statutes or rulings. Now for a quick review of signage requirements. If you put up a construction sign to promote the project, be sure to acknowledge all of the funders and key partners on that sign. Any sign must have both the CDFA and HUD logos, not less than 50% the size of the largest logo on the sign. The requirement to post a project construction sign can be waived if there is cause not to put up the sign. Also, remember to document the sign with photos. Do not ignore the requirement for the grantee to adopt a local drug-free workplace policy. It is required for nearly all federal programs. You should work with your local solicitor and/or human resources administrator to create a workable policy that you can enforce. The U.S. Department of Health and Human Services, HHS, has a toolkit that provides guidance and information on its website, which is found on this slide. The final section of this webinar reviews grievance procedures. Multiple compliance areas require grantees to establish grievance procedures. The potential types of complaints include discrimination, citizen participation, procurement disputes, acquisition and relocation, labor standard requirements, or decisions about eligibility and providing assistance to a household. Grantees should consider establishing procedures that are generic enough to address this broad range of potential complaints, rather than having multiple procedures for each type of complaint. Grantees can either adopt the sample grievance procedures included with the implementation guide or create their own procedures. These procedures will not replace or limit a person's right to file with a court or other administrative body, such as the New Hampshire Human Rights Commission for Housing Discrimination. If developing your own local grievance procedures, they should be written and available to potential complainants. And the process should include expectations that any complaints are responded to within 15 working days. Complaints and grievances are best handled at the local level. CDFA will forward complaints it receives about a project to the grantee. It is the grantee that is expected to address complaints, even when a subrecipient is administering the project. That concludes our presentation on grantee requirements. Should you have any questions, please contact a CDFA program manager using the contact information on this slide.